Good morning to all of you. Welcome to Legal Matters by Sai Baba Sankara. Video number 1480. In this video, we are going to discuss the check as enforceable debt or security. If the check, which is an instrument, is given for enforcement of liability or enforceable liability, okay, it attracts section 138. If it is given as a security, the provisions of 138 of the Negotiable Instrument Act will not apply. This is decided by the High Court of Gujarat, Justice Geeta Gopi, while deciding the case of CMSmith and Sons Limited. It is a cast iron company through Dinesh Mohanlal Panchal, he is the GPA holder, versus State of Gujarat. In criminal MP number 3246 by 2020 on 10th February 2022. The Gujarat High Court has clearly stated that the offence under section 138 of the Negotiable Instrument Act would apply or maintainable only for the checks issued for so-called enforceable debt, but not security. Very clearly they have stated. But sometimes they are interchangeable, whether it is enforceable debt or whether it is given as a valuable security. The court has to decide. Sometimes it will be confusing. So unless you know the facts of the issue, it is difficult for you to establish or to come to a correct conclusion. That's why let us start with the brief facts of the case. Right? Please remember, CMSmith and Sons. It is a company which is engaged in manufacturing cast iron. Okay, this has got built the so-called business relations with so many of the ancillary small companies also, like respondent number 1, respondent number 2, all these people, right? So actually, respondent number 2 and 3, they are all LLP. So they are partnership firms. They used to supply certain products which are necessary for the manufacture of cast iron. But it so happened that they supplied some defective products. Due to defective supply products, actually the company encountered return from the other customers. So even though they sent the cast iron mounts, they were returned because of the defective. This defect, where from it has come? It has come from R2, right? So this is the story. But R2 did not agree. Actually, these people, they have purchased almost 1 crore 12 lakhs 26,500 worth rupees products from them, but they were found to be defective. But still, R2 filed a summary suit before a Rajkot court. So, because against a company, against this CMSmith and company, for recovery of the money of 1.12 crores, which I have told you just now. So actually they have given the order, but since they are defective, the other persons, they have returned the properties. Now this is the litigation. CMSmith కంపెనీకి R2 వాళ్ళు కొన్ని ప్రోడక్ట్స్, ఈ క్యాస్ట్ ఐరన్ తయారు చేసే ప్రోడక్ట్స్ పంపించిన తర్వాత కానీ వాటిలో కొంత డిఫెక్ట్ ఉండటం వల్ల వీళ్ళ ప్రొడక్షన్ క్యాస్ట్ ఐరన్ వేరే చోట పంపిస్తాయి, తిరిగి వచ్చినాయి. సో వీళ్ళు ఏమంటారు, మాకు సంబంధం లేదు, మేము పంపించినప్పుడు మీరు ఆపలేదు, యూ హ్యావ్ టు గివ్ మనీ 1.12 crores. So they have filed a summary suit. So civil judge Rajkot passed a decree in favor of the so-called respondent R2. R2 ki decree chal, that means it has to be executed. Now CMSmith and company, they went for the first appeal, but first appeal was not so successful. Anyway, first appeal before the district judge. So actually, division bench of High Court. So they granted interim relief, but directed the company to deposit 50%, almost 43,40,061 rupees as security. But these people are not able to provide that much of security also. Ultimately, civil judge passed the attachment order. Since they failed to furnish at least the 50%, civil judge has gone to the extent of passing the warrant of attachment. So R2 and R3, they brought the warrant of attachment and they threatened CM Smith and Sons that they are going to actually remove the machinery and disrupt the production mechanism or production process of CM Smith. So at this juncture, they gave some checks. Now we are coming to the regular point. At this juncture, they gave some checks. 11 checks they have given. Out of them, one check is given as security. That is for an amount of 69 lakhs 62,879 rupees. So this check is only as security. That means if they are not able to pay the 10 checks, this will be invalid. This is what they have agreed. But they wanted to encash this check. So now the case is that they have produced the check or they have handed over the check in their account branch, but it was found dishonored, check bounced, no notice, and ultimately they filed the case under section 138 NIACT. Now at this juncture, CM Smith and Company filed an appeal. This application. Actually, they filed a petition under section 482, that is quashment of the proceedings before the Gujarat High Court. Right. So actually, after filing the case under 138, the civil judge has issued them summons according to 204 CRPC. So agreed by this, now they have approached the court for quashment of 138 NIACT. Right. Now the Supreme Court has clearly held that civil court, Raj court, person not at all authorized or legally authorized to issue the warrant as the manufacturing unit, that is S company, is not located in Raj court. Second, movable property or immovable property, they were also not located in its jurisdiction. So as per section 39 clause 4 CPC 39 clause 4, they are not competent to issue the warrant of attachment. Therefore, the warrant of attachment is quashed. Right. Second point, as regard the check. So please remember, the check was given as a security. So section 138 applies only to the checks which are given as a legally enforceable debt, but not to security. So the High Court, Gujarat High Court, placed a reliance on a case law, Lalit Kumar Sharma versus State of UP 2008. So this is nothing but gross misuse of justice and abuse of the process of court. So NIACT is also set aside. Now CM Smith and Company, they are safe. So of course it is their duty to pay back the money, no doubt. Whether the products are defective or not by of the R2, they should have rejected it at the earlier stage itself, or at least they should have deleted something as demurrage. So since they did not do it, definitely they are liable to pay. Anyway, let us see what will happen. As far as this case is concerned, two legal points are important. One, section 138 applies to only only legally enforceable debt, but not as security. Second point, section 39 CPC, civil court, Raj court. So you can give a warrant of attachment where the property is located, where the transaction is being located, but where the immovable or movable properties are located, but not other places. Therefore, civil court is also not competent. So very good judgment. Please read it since it is CPC. So many points are there. So please hear the video once or twice, and definitely you will be enriched with CPC legal knowledge particularly. Thank you very much.